The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 965, and it is coming to you on Monday the 2nd of March, 2020. On this program, I will continue the topic started last week, equitable interests. So this will be equitable interests, part 2. But as usual, before getting into the program, let me say deepest condolences to all families which have suffered recent bereavements. One short preliminary matter. Lawyer-client confidentiality. Just as you have doctor-patient confidentiality, so there is lawyer-client confidentiality. Basically, that means that a lawyer cannot disclose to anybody else the business he has with his client unless that business takes the form of matters in open court. I say this because every now and then someone will go to a lawyer and say to the lawyer, "Oh, my daddy is doing something, or you're doing something for my daddy, and he asked me to say this to you and this and that and the other." Or my mommy is overseas and she wants to find out about something with what you're dealing with her. Well, the lawyer is not at liberty to discuss with anybody, whether you are a parent or a child, a husband or wife, a brother or a sister, except the client, or except on the instructions of the client. So if you have any relative abroad who has dealings with a lawyer, it is no point the relative asking you to go to the lawyer to request this or that information. You can go and carry information to the lawyer. The relative should send a letter duly notarized for you to take to the lawyer to say, "I have authorized this person to come to see you to discuss X or Y concerning my matters." All right? So if you go to a lawyer for information about another family's business, and the lawyer says, "Look, I'm not free to discuss that with you," don't get annoyed with the lawyer. He is simply protecting the confidentiality of his client, okay? All right, equitable interests, part 2. As I mentioned to you last week, Monday, there are rights which a person might have in property which belongs to somebody else. Those rights might or might not be recognized by the law. So that if you think you have rights to property and that property belongs to somebody else, you should seek legal advice as to whether or not you do have rights, and if so, what can you do to establish or have your rights recognized. A typical case in which equitable interests exists in this country is the case in which somebody puts money into the construction of a property, a dwelling house, by somebody else on that other person's land. Let us say a man and a woman have been living together, not married. Because if you are married, your rights in property may well be legal rights. That is, you are entitled to those rights, not equitable rights. But if you are not married, then you can only have legal rights in property if there is a document duly drawn up and signed acknowledging your rights. In the absence of documentation, if you go to court, you have to rely on equitable principles. So, let us take the case of a man and woman living together in a common law union. They are living on a piece of land belonging to the man. They decide to either build or improve the house in which they are living. So they set about making construction, additions in cases, to the property. The common law wife gets money from relatives abroad, or she may have a little job, but somehow she puts money into the purchasing of materials to put on the addition to the house. She may even do physical work herself. She may help in jogging blocks, mixing concrete, cooking for the workmen, doing other things. So, gradually, this building is improved quite appreciably, thanks in part to the monies put in by the wife or the common law spouse. And then the relationship goes sour. The parties fall out. The man chases the woman out of the place. He says, look, get out of my house. And literally puts her out. He might even take her belongings and fling them outside. He shouldn't do that, but that happens every now and then. She will say, well, look, I have money in that house. My money helped to put on an addition to that house. My labor went into the addition. You can't just put me out and chase me and say I have nothing there. And the man usually will suck his teeth, quarrel, and say, you ain't have nothing there. This is my place. Go by your business. What is she to do? Well, she should go and seek legal advice. And if the evidence she produces to the lawyer satisfies the lawyer that she has enough to go before the judge, the lawyer could put in a case on her behalf against the man, claiming equitable rights, equitable interests in the property, saying that, look, because of the contribution she made to the property, to its improvement, to the putting on of the addition, she is entitled to have that contribution recognized by a court of law. and depending on the overall value of the house and the property, and the overall value of what she put into the property, the judge would be entitled to say, yes, I am satisfied that you have established your entitlement to certain rights in the house, in the property, to an interest in the property, and I am awarding you X, Y, and Z in terms of compensation for the loss or deprivation of those equitable rights, equitable interests. Note, please, that a case like that would be heavily dependent on the common law wife who wants to bring the case or who has brought the case, having credible evidence. And this is why I have been advising for years. If you are going to go into a joint venture with somebody which involves you putting money into property, make sure you have your receipts. Make sure you have proof of what you spent. It isn't enough if you go to court to say, well, I used to buy this and that, and I used to, buy a few sheets of galvanized. I used to buy a few sheets of plywood. I used to buy a few sacks of cement. I used to pay for blocks. I used to help to pay for sand and rubber and so on. The judge will ask you for proof of what you are saying. You see, in these matters, word of mouth cannot suffice. Because the man will say, no, that is not true. She didn't buy this and that and so on, as she is alleging. She is lying. She in turn will say, the man is lying. How is the judge supposed to decide the matter? If you have no evidence in the form of receipts or in the form of oral evidence by witnesses, you might be able to get a truck driver to go to court and say on your behalf, yes, I used to bring the occasional load of sand or abaca to the premises, and this is the woman who used to pay me the money. Or you may bring the block maker and say, yes, she used to buy blocks from me. She used to come and pay me X and Y to buy so many blocks and so on. Or she might bring a carpenter or mason to say, yes, I worked on the house, and when I worked, she is the one that paid me. Of course, the man will turn around and say, yes, she paid you, but she was using my money. It will be up to the judge to decide who he thinks, or she, as the case may be, if it's a female judge, who she thinks is the truthful one and who is telling lies. But without evidence of a credible kind, you are not likely to succeed in a court of law, because courts of law depend on evidence to make their rulings. So that where you are not married and you are spending your money on a property, on land belonging to somebody with whom you are living in a common law union, be very careful that you preserve the evidence of the amounts you have spent from time to time. Don't say, oh, no botheration will come out of this because we're moving good. Yes, you're moving good for the time being. But that is not always the case. The time may come when you may stop moving good. And you need to establish what are your rights, by proper evidence. And it can't be just your word against the man's word. You need something more. So that when you go to a lawyer for advice, the lawyer will ask you all sorts of questions, because the lawyer will be probing to see the quality of the evidence you have. And at the end of the interview, the lawyer may make some inquiries, and at the end of those inquiries, the lawyer may have to tell you, look, I'm sorry that you don't have a strong enough case to go to court. And you may flunks up and say the lawyer is unfair and say you want to go to court. But now, that brings me to another point. When you go for legal advice to a lawyer, the lawyer will ask you many questions, because the lawyer is trying to establish if you have a case, and if so, how strong it is. The lawyer will have an idea what the judge is likely to accept as good evidence and what the judge is not going to accept as good evidence. So that if the lawyer advises that you don't have enough credible evidence to go to court to bring a case, don't take it out on the lawyer. The lawyer is simply trying to save you money and time. And if a lawyer thinks you have no case and you insist that you want to go to court, any self-respecting lawyer will tell you, well, look, go to somebody else. I am not putting in a case for you if you don't have enough evidence to sustain the case you want me to bring in your behalf. And if a lawyer takes a case knowing full well that there is not enough evidence there, then the lawyer is doing something which is wrong. You should be told how you stand. And how you stand will depend on what evidence you have. You may say, look, so-and-so could prove that I was the one who spent a lot of the money, and you may be referring to the contractor who had the main job of putting on the addition in the house. The lawyer may check and find out that the contractor has gone away. So if the contractor on whom you want to rely to give evidence on your behalf is not available, then that evidence that the contractor might otherwise be able to give on your behalf is similarly not going to be available. And you can't file a case, and the lawyer will file a case for you relying on witnesses without checking out whether those witnesses are indeed still present in St. Vincent and Grenadines or indeed still alive. So that there could be many reasons for you to fail to establish your entitlement to rights in a property which belong to somebody else. I'm not speaking of a case where you are a joint owner of the property. I'm speaking of a case where the property, the land belongs to somebody else, so you can't claim to have an interest or a share in the land. You are simply wanting to claim an interest in the improvements made to structures on the land, or indeed to the erection of structures on the land. You see, as I'm always advising, there is a difference between what you think are your rights and what the law regards as your rights. Because in the scenario which I am using as an example, suppose the addition you're speaking about was made a long time ago, 15, 20 years ago. And the relationship goes bad. Well, when the judge examines the evidence, the judge may come to the conclusion that, yes, I believe you made a financial input into putting on the addition on the property, but you have been living there for the past umpteen years, 15 or whatever time period it is. And you have not been paying a rent, you've been living there rent-free, so you have got the benefit out of the contribution you made initially when the addition was going on. So the judge may come to the conclusion, yes, initially in the early stages you had equitable interest, but those interests have been satisfied by virtue of the fact that that was your dwelling place along with your common law spouse for a long period of time. And when everything is put in the balance, the judge may conclude, well, you are no longer entitled to be compensated for what you spent years ago because you've had the benefits of what you spent. And again, these are some of the things which a lawyer will take into consideration in deciding what advice to give to you. So that when a lawyer tells you he is not advising that you go to court with a matter, it isn't that he is bad-minded or he is friendly with your common law spouse and so on. It's simply that he is doing what he thinks is in your interest. Because going to court, is stressful, expensive, could be frustrating, and at the end of the day, you might lose. And when you lose, the consequences could be serious because in most cases, if you lose a case in the High Court, especially a land case, you would normally have to pay the costs of the other side. And in most land cases, those costs will work out according to our rules of court to $7,500. It's a lot of money. Therefore, when a lawyer advises you that you shouldn't go to court, it's because the lawyer understands and assesses that you simply do not have the evidence to put before the judge. Not that the lawyer will disbelieve your story, the lawyer would believe you. But the lawyer's belief cannot be a substitute for you having the evidence to establish your case in a court of law. And your own belief is not evidence on which a judge can rely to find in your favor when a contested matter comes before the judge for adjudication. So I hope you understand the importance of seeking advice in the first place, the importance of having evidence to back up your story, to back up your claim, and the importance of telling your lawyer the truth. I have had previous programs with the law and you with that topic. Tell your lawyer the truth. Many people think, okay, they can go and seek advice from a lawyer, hold back certain things which they know, because they might feel those things if they tell the lawyer it was so unfavorable on their behalf. Or give the lawyer half-truths, or sadly in some cases, deliberately lie and say things which you know full well are not true. Now, if you discuss matters with a lawyer and you're not frank with the lawyer, if you don't tell the lawyer the full truth, the advice you give to the lawyer would be based on the untruths you have told the lawyer and the half-truths. But if the matter goes to court, the court will tell you that you don't have enough credible evidence to sustain your case. Likewise, if you are a defendant and somebody sues you as a defendant, you're a defendant, you got sued. In cases where you really don't have the evidence to defend yourself properly, you tell that to the lawyer, and the lawyer will seek to have the matter settled before going to court, because the lawyer will know the consequences to you of going to court and failing to establish your defense in that case. So the bottom line is that cases in the High Court, particularly cases over land and property, are heavily dependent on the existence of credible evidence. Credible means evidence which is believable, strong evidence, solid evidence, not hearsay or things that, come from your imagination or things based on lies. All right? Okay, well, that is all from this program number 965. I look forward to being of further service to you next week, Monday, DV, for another presentation in this public service nation building series, The Law and You. Do have a pleasant week, ladies and gentlemen, brothers and sisters, boys and girls. Reflect on how fast 2020 is going. 2 months are finished. We're now in the third month of what was recently New Year. Time flies. So may the good Lord continue to bless all of us.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer P.R Campbell QC and brought to you on SVG-TV as a public service.